In April 2009, Pastor Stephen Anderson was charged with misdemeanor counts of resisting an order from a public official and obstructing a highway by the state of Arizona, which filed criminal charges following a high-profile confrontation at an interior Border Patrol checkpoint. The charges stemmed from events on April 16, 2009, at a checkpoint located on Interstate 8 near Yuma, Arizona. During the stop, Mr. Anderson refused to consent to a search of his vehicle or a referral to a secondary inspection area, citing his Fourth Amendment rights. The situation escalated into a 90-minute standoff that concluded when Department of Public Safety officers broke his car windows, tased him, and forcibly removed him from the vehicle. The case was heard in Yuma County Justice Court before Judge Elizabeth G. Underwood. On December 16, 2009, Agent Ernesto Gomez, who was present at the moment of the incident, was called by the prosecution. During the trial, after Agent Gomez answered the direct examination of the prosecutor, Mr. Anderson attorney, Mark J. Victor, had the opportunity to cross-examine him.
Did you testify earlier that you sometimes ask what country people were born in?
Yes, sir.
Is it possible to be born in another country and still be a U.S. citizen?
Yes, sir.
When you're at the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of their written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks or for the checkpoint itself, sir?
For that checkpoint.
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there? Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist.
Yes, sir.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in the room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may?
Please ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. Is there a citizenship there? If somebody traveling through there and they come to our checkpoint, they're U.S. citizens, they're free to go. If they're not a U.S. citizen, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
What is your answer that you were not aware of any?
Yes, sir.
Thank you.
Defense attorney Mark Victor begins the process of impeaching Agent Gomez by highlighting direct conflicts between his current trial testimony and his prior recorded statements. Impeachment is a critical legal tool used to challenge a witness's credibility by proving their story has changed over time. Under Supreme Court precedent, Border Patrol has the authority at a primary inspection point to conduct brief, routine stops without a warrant. However, the law distinguishes this from a secondary inspection. While a primary stop is for basic immigration questioning, moving a citizen to secondary for a prolonged standoff requires a legitimate law enforcement objective. By using these disclosed recordings, Mr. Victor demonstrates that Agent Gomez is contradicting his own account of how and why that transition happened. If the agent cannot keep his story straight about the reason for the secondary referral, it suggests the order was never lawful to begin with, casting immediate doubt on the reliability of the state's case.
To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen, and they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But then I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, do you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go.
No, sir.
Okay, now I'm confused again. I originally asked if you are unable to determine citizenship at the primary checkpoint, that you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
And what do you do with them?
I try to establish the citizenship there,
And suppose you can't.
and they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Mr. Victor impeaches Agent Gomez with a second inconsistent statement, this time from a prior telephonic interview regarding written checkpoint policies. Earlier in the trial, Gomez testified under oath that he was aware of these policies. However, Mr. Victor confronts him with a recording where he explicitly states the opposite. This contradiction moves beyond mere forgetfulness and into the territory of perjury, as defined by Arizona Revised Statute 13-2702. In Arizona, it is a Class 4 felony to make a false sworn statement regarding a material issue while believing it to be false. By forcefully acknowledging his own recorded words, Agent Gomez admits that his courtroom testimony was false. This is a potential to compromise state's witness knowingly provided false information under oath to justify the legality of the checkpoint operations.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the Canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not the
Yes.
dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked?
Correct.
And Agent Spoonamore gave you that signal because his dog alerted.
Correct.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary
Yes, sir.
because the dog said so.
Because the canine alerted to the vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration.
I don't know if there was a concealed person in the vehicle, sir.
Mr. Victor now shifts his focus to the legal justification for the secondary inspection, challenging the lack of probable cause. He grills Agent Gomez on whether a canine's change in breathing can truly be considered a trained, final response. At these checkpoints, Canine units serve as biological detection tools, trained to provide an objective alert when they encounter the odor of narcotics or concealed humans. While Agent Gomez insists that handlers are trained to recognize these subtle physiological shifts, Mr. Victor argues that this is dangerously subjective. While a certified narcotics dog's alert usually provides a probable cause, the federal case law, such as United States versus Parada, distinguishes between a vague alert and a specific trained final response, like sitting, barking, or scratching. According to Mr. Victor, the dog failed to perform its trained actions. The agent's interpretation was purely a matter of opinion and not a verifiable fact. Also, Agent Gomez reinforces the K9 unit, which alerts them of illegal immigration. Mr. Victor's arguments there was no objective alert related to it, so in consequence, there was no probable cause. Without probable cause, the order to exit the vehicle would be unconstitutional and unlawful. Therefore, Pastor Anderson wasn't obstructing justice.
When you directed Mr. Anderson to secondary, he was going to secondary to get his car searched, correct?
Correct.
Regardless of anything else, his car was going to be searched when he went to secondary. That was your intention, wasn't it?
Along with attempting to establish citizenship, sir.
Along with probably a whole lot of other things, but his car was going to get searched, wasn't it?
Yes, sir.
He was going to be made to get out of his car,
Yes, sir.
and the car was going to be searched.
Yes, sir.
And the dog decided that.
The team, both canine and handler, decided that, sir.
Well, the dog is the one that alerted, correct?
Correct.
When you're at primary, you can decide to send people to secondary, correct?
Yes, sir.
Someone pulled up the primary with their passport open, showing that they were a citizen, your decision would probably be just to let them go, correct?
Yes, sir.
Have you ever sent someone to secondary who had absolute proof of citizenship out for you to see?
Yes, sir.
For what?
Canine alert, sir.
Okay. Any other reason?
Yes, sir.
For what?
Their demeanor, the way they're acting, their story.
But if the canine alerts, if you're told the canine has alerted, it doesn't matter what you think. That car is going to secondary.
Yes, sir.
You can't overrule the dog.
No, sir.
You can't look at Agent Spoonamore and say, this guy's fine. Look at him. He's a white guy, short hair. He's got identification. But when we let him go, he's not Mexican. You can't say that, can you?
No, sir.
He's going to secondary.
Yes, sir.
Because the dog is a separate operation from what you're doing.
Yes, sir.
You're not his supervisor?
No, sir.
You can't overrule the dog.
No, sir.
So, Mr. Anderson refused to go to secondary.
Yes, sir.
Why didn't you arrest him?
Objection, Your Honor, relevance.
Your Honor, they opened the door when he asked what his role after this point was on the tape. He asked him what his role was, and now I'm delving into what his role was.
Objection is overruled.
Why didn't you arrest him?
At the time, I didn't have a reason to arrest him, sir.
He hadn't committed a crime?
No, sir.
No violation of federal law?
No, sir.
Are you, or were you at the time certified to enforce any state laws?
No, sir.
Are you now?
Yes, sir.
What are you cross-certified to do regarding state laws now?
Issue citations for narcotic violations, sir.
Anything else?
That is it, sir.
Only narcotic violations.
Yes, sir.
To the best of your knowledge, was that the status of Canine officers on April 14th?
Can you state the question, sir?
To the best of your knowledge, on April 14th, was it the status of Canine officers, specifically Agent Spoonamore, that he could enforce state laws, but only to the extent that he could write citations for narcotics violations?
No, sir.
Could he enforce more state laws?
Not to my knowledge, sir.
Okay, so the answer to my question would be yes, that's, to the best of your knowledge, that's all he was allowed to do. I want to make sure I'm not trying to confuse you. If I ask you a question and you don't understand my question, please ask me to repeat it. Sometimes I lose track from the beginning to the end. To the best of your knowledge, on April 14th, was Agent Spoonamore's authority as it respects state laws only to issue citations for narcotics violations?
No, sir.
Then what was your understanding?
The Canine team is also there to look for concealed people, sir.
I'm talking just as respects state laws, not federal laws. I assume you all are empowered to enforce federal laws, okay? Just state laws. The only thing Agent Spoonamore could do is write citations for narcotics violations.
To my knowledge, yes, sir.
That's the way it is now?
Yes, sir.
To the best of your knowledge, it wasn't any different back then?
Yes, sir.
Yes, sir, it was different, or yes, sir, that's the best of your knowledge?
That's the best of my knowledge, sir.
Thank you. Could Agent Spoonamore affect a physical arrest for someone for possession of narcotics under state law?
Yes, sir.
Could he take him to jail? Let me ask this differently. Assuming his authority then was the same as your authority now. So I'll ask you about your authority now. Fair enough?
Yes.
Okay. Your authority now as a canine officer, you can write citations for violations of what laws?
Sir, I'm still currently going through the training,
Uh-huh.
so I'm not done with all my training, so I'm not exactly sure on all of that.
Is it your understanding, and you can tell me if you don't know, that's a legitimate answer if you don't know, that canine officers can write citations, but that's a bad question. I'll withdraw that one. So your understanding that Agent Spoonamore had the authority to arrest someone to take him to the Yuma County Jail and charge them with the state offense?
I am not exactly sure with the procedures with that, sir.
Or was it more write a citation like writing a ticket and letting them go?
Like I said, sir, I'm not done with all my training, so I do not know the process of that.
Fair enough.
Mr. Victor directs Agent Gomez to confront the limits of his own legal authority. And before that, Agent Gomez admits on the stand that Mr. Anderson had not committed a crime at the moment he was ordered into secondary inspection. If no crime was suspected, the command to exit the vehicle fails the definition of a lawful order under Arizona Revised Statute 28622. For an order to be lawful, it must be supported by a legitimate objective that respects constitutional boundaries. The defense further solidifies their argument by citing federal jurisprudence like United States versus Place. While a dog's sniff itself isn't a search, the results must provide an objective basis for further intrusion. Because the alert was nothing more than a subjective change in breathing, and the agent admitted no crime was suspected, the entire escalation is reframed not as law enforcement, but as an unreasonable seizure. On August 13, 2010, the jury delivered their verdict, not guilty on all counts. Pastor Stephen Anderson's acquittal was a complete rejection of the state's case, leading him to later file a civil suit against the officers involved for the violation of his constitutional rights. Our next case occurred on September 14, 2022. Defendant Raymond Fernandez stood trial in Lyon County District Court on 3 criminal charges: operating a motor vehicle under the influence, indecent exposure, and possession of an open alcohol container in a motor vehicle. The charges stemmed from events that occurred on August 21, 2020, when Officer Shannon Oliver of the Eddyville Police Department observed Mr. Fernandez at a car wash located on Highway 93 South in Eddyville, Kentucky. Officer Oliver initiated contact with Mr. Fernandez after allegedly witnessing him urinating in public, which led to a DUI investigation. During that encounter, Mr. Fernandez was administered field sobriety tests, which Officer Oliver claimed he failed and subsequently refused to submit to a breathalyzer test at the Lyon County Jail. On September 14, 2022, Officer Shannon Oliver was called by the prosecution. During the trial, after Officer Oliver answered the direct examination of the prosecutor, Mr. Fernandez's attorney, Larry Foreman, had the opportunity to cross-examine him.
Let's talk about something we haven't talked about yet. You've been trained on how to do field sobriety tests, right?
Correct.
And in this particular case, when you stopped and arrested Mr. Fernandez, he was over the age of 65, right?
I believe so.
And you were trained that if you administer the test to an individual over the age of 65, the veracity could be compromised. Basically, the tests could not be reliable if the individual is over the age of 65, right?
I was trained that if the individual says that he has any type of physical ailment that could potentially affect the result of a test, then we take that into consideration and we don't do the test. Anyone over the age of 65 that's a perfectly healthy individual, we will do the test, and best I recall that night, he didn't mention any physical ailments.
That was not my question. My question is, your manual states that any individual over the age of 65, if administered these tests...
Argumentative and hearsay and lack of foundation. Response?
Your Honor, if I may rephrase the question.
You may.
All right. Let's talk about your training. Do you remember your training?
Sure.
It was 15 years ago. It was a long time ago, right?
Yeah.
But do you remember receiving a DUI detection and enforcement manual that is promulgated by the National Highway Traffic and Safety Administration?
Yes.
Do you remember in that manual a page that states that if an individual with, like you said, either injuries, medical ailments, or anyone over the age of 65 is given these tests, the validity may be compromised? Do you remember that?
I don't believe that that was the situation in this case, but it could be.
That's not my question. My question is, do you
I'm
remember that from your training?
fixing to finish my answer if you'll let me. I don't believe that that was the situation in this case, but it did state that that could be an issue, yes.
Thank you.
During cross-examination, Mr. Foreman challenged Officer Oliver's administration of the standardized field sobriety tests by referencing the officer's own training materials. Mr. Foreman directed Officer Oliver's attention to the National Highway Traffic Safety Administration's Manual on Standardized Field Sobriety Testing, which explicitly acknowledges that individuals over the age of 65 may experience difficulty performing these tests due to age-related physical limitations. By establishing that Mr. Fernandez fell within this age category at the time of his arrest, Mr. Foreman laid the groundwork for an argument that any perceived failure of the field sobriety tests could be attributed to Mr. Fernandez's age rather than intoxication. This line of questioning served to undermine the reliability of the test results as indicators of impairment, suggesting that Officer Oliver either failed to account for this documented limitation or chose to disregard it when forming his opinion that Mr. Fernandez was driving under the influence.
Now, Mr. Oliver, do you recall being notifying dispatch of the fact that you are stopping a vehicle on
Yes.
August 21st of 2020?
Yes.
And what does dispatch do when you notify them that you are on patrol and you're about to initiate a stop?
They update the CAD system.
What is the CAD system?
Basically where they just document the time so we can keep up with everything that's taking place.
Does it stand for computer assisted dispatch, to your
Yes.
knowledge?
Yes.
Now, so far in your whole testimony today, we have not heard that there was a second police officer on scene.
Correct.
Is it your testimony here today that on August 21st, 2020, you were the only officer conducting the investigation of Mr. Raymond Fernandez?
After reviewing the CAD system recently, I do recall now that there was another officer there.
So this is not what you testified to previously, correct?
Correct.
Previously, you have been asked if there was another officer on scene, and you stated that there was not, correct?
I believe I stated that I didn't believe so. I wasn't for sure. But after, like I said, after I reviewed that recently, there was another officer there.
So you are asking the court to correct your prior testimony about this case?
Correct.
Do you recall, after reviewing the CAD detail, what was that officer's name?
Deputy People.
Mr. Foreman impeached Officer Oliver by exposing an inconsistency in his testimony regarding whether he was alone at the scene. Officer Oliver initially testified that he was the only officer present during the encounter with Mr. Fernandez. However, Mr. Foreman confronted him with computer-assisted dispatch records, which documented the presence of another officer at the scene. Under Michigan Rule of Evidence 613, a witness may be impeached by showing that they have made prior inconsistent statements, and while CAD records are not sworn testimony, they constitute contemporaneous business records that carry substantial weight in establishing what actually occurred. When presented with this contradiction, Officer Oliver was forced to retract his earlier testimony and acknowledge that another officer had indeed been present. This admission can damage Officer Oliver's credibility before the jury, as it demonstrates either a failure of memory regarding a key detail of the arrest or a willingness to provide inaccurate information under oath, which constitutes as perjury.
What time did you stop Mr. Fernandez? Do you recall?
I would need to review my citation.
If I may approach the witness, Your Honor.
You may.
21:26, which would be 9 p.m. Not, or 9:26 p.m., I'm sorry.
9:26 p.m.?
Yes.
And what time did you arrest Mr. Fernandez?
9:37 p.m.
If I may approach the witness, Your Honor.
You may.
So 9:26, you stop Mr. Fernandez, correct?
Correct.
And you arrest him 11 minutes later at 9:37.
Correct.
Did you wear a body camera of any kind on August 21st of 2020?
Unfortunately, our department doesn't provide body cameras.
Did you have a dash camera in your vehicle on August 21st of 2020?
Also is not provided.
No further questions, Your Honor.
Mr. Foreman further challenged the legitimacy of the arrest by highlighting the compressed timeline between Officer Oliver's arrival at the scene and Mr. Fernandez's arrest. According to dispatch records, only 11 minutes elapsed from the time Officer Oliver arrived at the car wash to the moment Mr. Fernandez was placed under arrest. The NHTSA manual emphasizes that these tests must be administered in a standardized manner to be considered valid indicators of impairment. By establishing that Officer Oliver completed his entire investigation, including observation, questioning, test administration, and arrest decision, in roughly half the time normally required for the tests alone, Mr. Foreman effectively argued that Officer Oliver could not have conducted a thorough and proper DUI investigation. Officer Oliver had predetermined his intent to arrest Mr. Fernandez before conducting any meaningful investigation, rendering the field sobriety tests a mere formality rather than a legitimate investigative tool. Following the trial, Mr. Fernandez was acquitted of all charges. These cases demonstrate precisely how profoundly a trial's outcome can hinge upon witness reliability and the considerable efforts defense counsel might undertake to undermine such reliability. Throughout their questioning, both defense attorneys guided jurors numerous discrepancies within the officer's testimony, ranging from their inaccurate testimony by the causation of the facts or the presence of other officers with them. Through exposing these conflicts with the witness's previous testimony, the defense attorneys assured the jury that those testimonies weren't accurate. In the end, the jury cleared the defendants from their charges from the state. Please share in the comments if there exists a legal matter or courtroom exchange you would like us to examine. We appreciate your time, and please remember to like and subscribe so we can continue promoting a better educated community.